works like a Ferrari.
Hey, we're asking.
It's a, you can't do it.
Your Honor, I see that Mr. Nichols' remaining case, the Stalker case, is on the same docket. And it says sentencing, but I don't think that's correct. Just don't find that.
It just-
Didn't.
How can there be a sentencing when he didn't
Well, I
leave? Well, it's obvious a mistake.
No, I just,
All of us follow each other, when we set it for one.
okay, and I just wanted to make sure that.
Well, that's gonna be dismissed, right? Is that what?
No, sir.
Okay. So this is clause number 39549.
Yes.
This one.
Yes.
And then there's still 37734.
Yes, I would like to keep it.
All right, it's called State of Texas versus Jason Gregory Noble.
Your Honor, should I bring up the other witness?
Here represented by his attorney and the state's attorney, Mr. Rose, representing the defendant. And the state's attorney is present. Mr. Noble earlier is.
I'll do cleaner business.
Have you already entered a plea on this?
Jury trial,
Oh, the jury.
he opted for you to determine sentencing. If I remember correctly, Judge, there was a plea true as to the
All up with the.
ours. So his exposure is 25 to life.
It was
Yes.
a second degree felony just on paragraph 1.
Yes, sir.
And then he pleaded true to paragraphs 2 and 3. Does that make it a habitual felony?
Yes, sir.
Okay, 25 law.
Yes, sir.
All right. Pre-sentence report has been tendered to the parties. Any objections or changes to it from the defense
Mayor.
or states?
No, sir.
Okay. The agreement is, again, it's open to the court for sentencing under the punishment range that is applicable under these circumstances. So what says the defense?
Your Honor, I would ask the court to take into consideration that although there is an extensive history of assaultive type cases and offenses involving violence, I would ask the court to take into consideration that Mr. Noble was introduced to violence at a very young age, 13 years old to be exact, by his father, when he was at a critical developmental age in his life, and began with assaultive offenses as a juvenile as young as the 11th grade. And it's kind of continued on since then. And Mr. Noble has not received any kind of treatment for his anger and his aggression ever. And
How old is he now? How old is he?
51. He's 51.
Whose fault is that?
And I'm not saying that it's anybody's fault.
Oh,
I'm just
okay.
pointing
Well,
out
we're gonna know
the fact that he has not received any kind of psychiatric treatment or counseling or any help to manage his anger issues.
So it's nobody else's fault.
Yes, sir. And on top of that, he also has been diagnosed as being bipolar. And he admits that he was prescribed medication but he stopped the medication. And I would like to point out that there's never been any kind of medication management or oversight, and that may have contributed to some of the anger issues and his overreaction in the present case.
You're cryptic. What does that mean?
Which part?
There's no oversight, and what does that mean?
Well, meaning that he didn't have any help with,
When you prescribe medicine, when you're at home, you take medicine as prescribed. We all do. The doctor doesn't come in and says, okay, I'm going to watch you in video to make sure you do it. We're grown-ups. You're prescribed medicine. You can either take it or not take it. It's free will.
sure,
And if you don't, then if something bad happens because of that, then whose fault is that?
well, Your Honor, I'd like to point out, in Officer Riley's report, that because he was not receiving mental health treatment and going to regular counseling sessions and getting, that they could not ensure that he was receiving this medication.
Why not?
Well, because it's just never been ordered in any of the times that he's
Wait,
ever
wait.
been on probation.
Hold on. He's not going to regularly schedule doctor appointments? That's what you just said. Whose fault is that?
Treatment.
Okay, okay. Well, who ordered the treatment?
Well,
Was it recommended by a doctor? But you didn't go.
I was traveling in town.
What, that's your, whose fault? Okay.
okay. There's also been an extensive problem, extensive history with substance abuse. And I'd like to point out that Mr. Noble has never received any kind of treatment or rehabilitation or therapy relating to his substance abuse issues. He did report that he was going randomly to NA and AA, but the last one was in 2018. So taking all of these things into consideration, I would ask the court, when it discusses the sentence, that it show leniency. Mr. Noble, on the date of this offense, or the date that this offense occurred, he truly believed that what he did by trying to disarm Mr. Knighton with a weapon, that he was saving his life and his mother's life. Based on the fact that, according to Mr. Noble, as it came out in court during the trial, Mr. Knighton had discharged the gun prior to that evening when he was high on methamphetamine, or methamphetamine. And so, Your Honor, even though he did overreact, the injuries were severe, but he truly thought that he was doing what was necessary to get the gun away from Mr. Knighton. And in the supplemental PSI report, Mr. Knighton himself states that he has forgiven Mr. Noble, that he actually resided with him when he was out on bond after the current offense. They've set aside their differences. They call each other, or Mr. Knighton and his mother have continuously contacted him and spoken to him on a regular basis. And although they did not appear, and I'm not making excuses for them, but they really did not want this case to go forward. And unfortunately,
Why do you think?
well, because he didn't think that he should serve any more time, that he's already served time, and that's according to what's in the PSI report. It's time served. That's what it should be. So the victim himself is telling the court and everybody that he comes into contact with, in addition to signing 2 non-prosecution affidavits, which, never came out because they didn't appear. He didn't appear in court. He has consistently held the position that he did not want Mr. Noble to be punished. for this. And why would a person do that? It's not because he was scared of him.
I'm sorry, the victim, as we recall,
Yes.
had the gun, the barrel of the gun imprinted on his forehead.
That is correct, Your Honor. I mean,
Gee.
and I'm not
Well, what do you-
downplaying the injuries.
What do you think could be reasons? Maybe a victim like that. This court has never seen such a thing. Never seen somebody had to jam a hot metal. The gun had been fired in just a few seconds, stuck up against the forehead and burned into the man's forehead. The barrel of the firearm. How
That's next Friday.
ruthless is such a thing? How ruthless. They had to think the next moment the trigger will be pulled and there's no escaping it. A bullet goes through your brain.
Well, Your Honor, I'd like to point out that at the time that the gun was used to hit Mr. Knight in the forehead, the chamber or the magazine had already been expelled and the bullet in the chamber had been ejected. And then that's according to his own testimony, and it was found in his pocket. Mr. Knight.
So play down the fact that he puts a burning hot piece of metal in the man's forehead. Play that down, would you please? That is as mean-spirited as it gets. What? Okay. Oh, so was he doing it for fun? No, he was doing it to hurt the man. It was just an act of meanness.
Your Honor,
You were-
can I call Mr. Noble? He would like to address the court, if you would give him the opportunity.
Yeah, that's you?
Yes, sir.
Raise your right hand. You solemnly swear or affirm testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Lower your weapons. Go ahead.
And I just want to apologize, Jill Stevenson, for wasting your time at work time. I did not want to go to trial in this case. I was in English, Mr. Hand has made an offer to me. My stepfather, he comes to see me regular up here in Jefferson County, in there 2 years. And I told him that the offer was 20 years. And they told me, do not sign for 20 years. And I was devastated to leave, but the offer was for 20. We have forgiven each other about the altercation. But if it was a saying just 2 seconds ago about the pistol thing, my stepdad did fire a firearm previously about 2 weeks prior to this inside the house. And it really scared me, scared my mother. And there's a lot of other episodes.
So it's his fault.
No, sir, it's not his
The
fault.
jury found otherwise, you know that.
Yes, sir. I'm going to respect the jury's decision too.
All right. Let's respect the jury's
Yes, sir.
decision, finding you guilty of aggravated assault, family violence.
Yes, sir. And there's no excuse for me acting like that, behavior like that. There's no, I understand that. But I guess I overreacted in the heat of the moment.
Which time?
Knowing what happened.
What about your prior convictions, which are crimes of violence? Let's see, arson,
Yes, sir.
and what, after that, aggravated assault, another aggravated assault. You were convicted of that in 2010. How many violent crimes do you get before you're held accountable?
Yes, sir.
And I'm looking at your criminal history.
Right.
How many convictions do you have?
She said I had several misdemeanors.
No, no one should know more intimately about their actions than themselves. How many convictions do you have?
I have 3 felonies. Prior convictions on like she's 20 or 30 misdemeanors.
You see anything wrong about
Yes,
that?
sir. Very wrong. Very, very.
After all of those, now you're here before the court for another crime of violence. After 20 some odd convictions, we all see a consistency that should have been dealt with 25 convictions ago. You should have learned a lesson. Okay.
I'd like to call Philip Jones, who is a childhood friend and boss / coworker of Mr. Noble.
Come on. Come on. Wherever that person is, that's who that is.
Yes.
Okay, what is your full name, sir?
Just Philip James Jones.
Raise your right hand. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Lower it up.
Uh,
No, it's question and answer.
Okay, all right.
Go ahead.
Mr. Jones, your name is Philip Jones, is that correct?
yes, ma'am.
And how long have you known Mr. Noble?
Since he was probably 12, 13 years old.
And
How long?
12 years old.
Yes.
since Mr. Noble was
I'm a
12,
little on supervisor.
and what type of job was this?
He's scouting.
Okay. Now, did you ever witness any violence in Mr. Noble's household when he was younger?
Yes.
Could you describe that?
Well, I can tell you, like, when we were kids, we were going to fight it out. We'd go to fight it out in the backyard. And if we did something wrong, we would get a whipping. When he was a kid, he would get beat up by his dad, with his fists. And, so,
Okay,
Oh, well.
I'll be there.
uh,
When you say he was beaten up by his dad with his fists,
Yeah.
can you be a little more specific? Like where his dad punched Mr. Noble?
he would just basically take him and beat him, punch him with his fists in the face, in the back, wherever he turned. And then he would get away and neighborhoods and we could like,
Okay. Now, Mr. Noble's father committed suicide when his father was 45 years old. Is that right?
right.
And how old would Mr. Noble have been?
He was probably, well, he was in prison when that happened.
Okay, so he was an adult.
He was in the, yes,
Okay.
27.
correct.
Thank Okay. Is
No,
there,
so wait, hold on. Your father died at 2001 at the age of 45 by suicide. Just with this stage. I'm sorry, you were born in 74.
Listen,
So that's 27 years.
I thought it was.
Here's the-
I should know more about this than you do. Go ahead.
is there anything that you would like the court to know? Well, let me ask you this. Did you ever know Mr. Knighton, the complaining victim in this case, to use drugs?
Yes.
And how do you know that he used drugs?
I know that he used drugs. He had my nephew and his Jason's son used up drugs when they was a kid. And so that's back when Logan and Caleb were young. Logan got into some trouble with Kim, and they were shooting up. He was shooting them up with cocaine, not cocaine. I think it was crystal meth at the time.
How do you know that?
I don't know that. Logan is my nephew.
Okay, and
And Logan's mother is the one, that actually that made them get away from there because of what was happening with them doing drugs at Jason's mom's house.
Well, what did the adults do about telling the authorities so that someone could be held responsible?
No,
You don't really know. You were a kid.
well, no, I wasn't a kid. Logan is my nephew. Logan is.
I'm talking about when you were watching him.
No, he was in prison when this happened.
Okay.
When Kim was doing drugs with Jason's son.
So what adult figure needed to talk to authorities to, that's a
That would have
crime.
been Logan. That would have been Logan's mother. Yes, sir.
But other people knew about it, right?
Yes, a lot of people knew about it.
But nobody-
I don't know that they filed any charges on him for that. No, I did not.
now the night of the incident, were you contacted by,
Jason's mother.
and Jason's mother is,
Yeah. Jason's mom.
okay,
Yeah.
Mrs. Knight.
Yeah, that's Mrs. Knight. Miss Yarline. Yeah, I know her first name. Miss Noble.
She had your phone number
Yes,
and she contacted you.
right.
And what was she wanting you to come over for?
She was wanting me to come over to calm Jason down because
Okay, go ahead.
Kim had fired off a gun, and then Jason tried to take it from her and hit him with the gun and that.
So did she tell you that, Kim had fired a gun? And that Jason,
Objection, that's a hearsay response.
Sustained.
present sense impression exception, Your Honor.
Overruled, the overrule. It's hearsay. There's no way that this can be tested by cross-examination.
Your Honor, if I
I made
may,
my ruling. Thank you. Move on.
no further questions, I pass the witness.
Anything from the staff?
I have no question to this
Anything
witness.
else you wanted to add, sir?
Yes, sir.
Go ahead.
I've known Jason all his life. He has, had a little rough life. He's always done anything for me, and and the whole time that I've known him, he'd give me a shirt off his back. He'd give any one of his friends a shirt off his back, and he would protect you like you were his father. Just like he would have protected his mom that night, he would protect you. I can tell you, he stayed with me for almost a year and a half after he got out. When I bonded him out, my grandkids love him. They miss him to this day. He's a good person. He needs some help with his anger issues. He's never gotten to deal with that, but I can tell you, he's a good person. He don't deserve to go through the rest of his life.
Wouldn't you agree that a person really is judged by the decisions they make?
Yes, sir. And I can tell you, my mom was murdered by her husband, beaten to death. And I wish I'd have been there today to take that from him and kill him instead of him killing him.
Oh, I understand. Self-defense is
Yeah.
under the law.
So you have to.
But the defendant, I'm looking at, the defendant has been convicted. He's been convicted of arson and was sentenced to 20 years in prison for arson. An aggravated assault, sent to 8 years in prison in that case. That was before this one. All right. Then we're talking about, he was convicted of terroristic threat, harassment, family harassment, convicted in misdemeanor court, sentenced to jail in those, assault, family violence, terroristic threat, assault, family violence. All those were convictions. Don't you think that this is a consistency of bad choices? We're talking about violence, crimes of violence. How many mistakes do you get to make before you realize, this isn't the right choice to make?
I
It's a tough.
I totally understand that.
I know.
And I know about a lot of those cases, especially the one with Carl Kruger.
I don't know. I don't know who people are involved in this. I'm just looking at his convictions,
And,
which stretch back to 1992.
And what I'm asking, can you give him a little help? You know what I mean?
Well, first of all, the help needs to begin with the person who's been making a mistake for 33 years. 33 years as an adult. I mean, it's like you and I. We're all judged by the choices we make. And when we put our hand on the stove, it burns us. We go, well, we're not going to do that again.
Well, I'm not asking you to make him a better person. I'm asking you to give him a chance to put him in a type of program that can get him to a better person instead of going to.
What are you suggesting is going to change his demeanor?
What I'm suggesting is going to.
What do you suggest?
I suggest counseling with
What kind of counseling?
mental counseling.
What is wrong with him that you are aware of medically?
What am I aware of is medically that he don't take his bipolar medicine. The only reason he couldn't take it whenever he was at my house because he was in between jobs and then so I can tell you as a standpoint, if you don't have the money, how can you take the medicine? You know what I mean? And then if you go in and off on that, that's a whole other way out of
Yeah.
my belief.
Okay.
But I can tell you that working through your mental problems with some type of counseling is better than going and fighting.
I understand, sir. I
You know what I
understand, but I don't know why things weren't done 33 years ago,
Yes, sir.
and here we are.
The
Is this man
things that they don't.
really excused? Is this man excused?
Yes.
Okay. Thank you, sir.
Thank you.
Who's next? Who's next?
That is all I want.
Okay. Go ahead. Estate, did you have anything you want to add? What's everybody arguing for here on?
25 years.
Go ahead. Is there anything else you want to add?
No, you're
Judge, I appreciate Mr. Noble's friend showing up and speaking for him. However, the truth is that he was interviewed by law enforcement, never offered any of the comments that he made today about who said what, when, and where. And all that's just another great example about how Mr. Noble has done everything he can to try to manipulate the system. Let's start with his victim in this case. He did come to my office and he did give me a affidavit of non-prosecution.
You're talking about.
I'm talking about Mr. Knighton. And as is my practice, whenever someone comes to the office with an attempt to try to drop charges, I visit with them. And one of the first things that I ask them is, did these accusations occur? That's routinely what I do every time. And Mr. Knighton said, yes, it happened. I have to have some peace at home. The only reason why I'm doing this is because my wife's making me do it.
Jack to the hearsay, Your Honor.
Okay. Sustain.
So the reality is, after his state confirmed that the accusations were true from Mr. Knighton, so that's why I proceeded forward. He was represented by different counsel. They went through other efforts. They actually brought Mr. Knighton in. They got him to do a different affidavit saying that those things didn't occur. But the facts are what the facts are, and that's what was presented to the jury. These arguments that he makes today about trying to disarm them and discharging them, that he allegedly overreacted, all those arguments were presented to a jury and were found lacking. They found him guilty. And what we see here today is just another situation where Mr. Noble does not accept responsibility for his conduct. Even his counsel's argument starts out blaming his father, which you heard from Mr. Jones, about his upbringing, that he's never had any treatment, that he's made his own decisions about whether or not he's going to take his medication. The reality is that he committed this offense, Your Honor. I'm happy to note, recalls all the details about the pure meanness of this particular act, that a gun that was fired was then jammed into the victim's forehead. The only way we could have gotten those injuries is if it was hot from that shooting. You'll recall that the man was sitting in his chair and there were bullet holes by where he was sitting, all fitting what he told officers on scene. Those
Object, that's incorrect. That's a mischaracterization of the evidence. There was only one bullet hole that was found, and that was by the forensic analysis or analyst that testified.
There were 2 bullet holes. The argument was whether or not there were 2 or 3 bullet holes, and the record will speak about that. So the end result is, again, he's just not accepting responsibility. If we're going to give somebody leniency, if we're going to give them a break, we look to determine what's their conduct. This man was out on bond on a stalking charge. I'm not going to address whether or not those charges are true or not. What I want to address is the fact that he was indicted, he posted bond, and what did he do? By his own admissions in this PSI, he continued to use methamphetamine all the way up until 2023 when he went into jail. That does not comport with your bond conditions, nor does it's meth is against the law. It's continuing breaking of the law. So if we're looking for leniency, wouldn't somebody's conduct be different? His own records indicate that this man is a menace to society. He has let me count, Judge. He has 8 misdemeanor convictions. Of those misdemeanor convictions, 2 of them were given an opportunity to do probation, which were revoked. In addition to that, he's got 2 felony convictions, all of which I was prepared to prove up to a jury because I did not know they were going to you until the morning of jury selection. Both of those priors, he did not admit to the offense. He was found guilty by juries in each one of those scenarios. And those sentences that are reflected there is what a jury decided. For some reason, he made the option to switch over and allow you to make the decision. It's 25 to life. It just goes to how this man has manipulated the system. We issued writs of attachment for the Knightons to bring them down here. I was prepared to prove it up without them, and I did. But the entire time that the trial took place, we were searching for those people. We were monitoring the jail calls. There was contact between this man and his mother constantly about the trial, all throughout the trial while it was done. And so what happens after we get done? We get a PSI that says they couldn't get a hold of the victims. But ironically, before we start this sentencing, they knew about the fact that it had been updated. I didn't. You're giving that.
That's
I was,
objection.
if I may.
That's incorrect too. I did not learn about that until today when Mr. Noble told me.
Thank you, because that's the whole point. Mr. Noble knew. Mr. Noble knew. Mr. Noble did the conduct. Mr. Noble's history is on trial here. Mr. Noble has done everything he can to manipulate the system, including bringing up his childhood friend.
Yeah.
The day of accounting is
This
today.
supplemental report, this was information that the officer received 3 days ago. 3 days ago, so it's new to everybody.
All right. One other thing out of his history. He was given a federal sentence, Judge. So he pled true to what's in front of you that doesn't include the federal sentence. Why I want to point that out for a second is it was not a very lengthy sentence, but as Your Honor is familiar with, whenever someone gets a prison sentence in the feds, they get supervised release, similar to our probation, but it's post, right?
Mm-hmm. Yeah.
He couldn't make those terms either, Judge. That was revoked. So when you weigh it all out and you separate all these things, we're looking to determine, what's the safest thing for Jefferson County. 12 of our citizens disagreed with the arguments that he's made today. They held him responsible without having heard from the victims. They know that the exposure is 25 to life. I am asking that the court sentence him to 40 years.
Okay. You have a chance to rebut. Go ahead.
Your Honor, I would just point out that Mr. Noble is not trying to manipulate the system. He's doing what he has rights to do. He's calling witnesses to testify on his behalf. He admits that his actions that day were wrong, that he overreacted. He understands that. So he's not escaping accountability or trying to say that he's not sorry and remorseful for the way that things occurred. And so I just want the court to be aware that the statements made by Mr. Ham are incorrect. And that's all I have, Your Honor.
Anything else you want to add, sir?
Yes, sir. I'm really sorry about all this. And I know this is very serious. And I didn't tell Philip Jones nothing about coming today. He did it on his own. I didn't. And my mom came to Wednesday in visitation and told me that a man named Riley called. I had no idea what was going on. And my mom said that my stepdad had talked to him. That's how I knew about that situation. But Your Honor, if you send me to prison for a long time like that, I don't know how I'm gonna recover from nothing like that. And I mean, I've been in prison twice, and I tell you, it's just no joke. It's tough. It's hard.
It's supposed to be a
Yeah, I'm just saying,
punishment.
it's just nobody's down there happy. It's all nothing but a bunch of angry people. And I just think it'll make me way worse if I'm sitting in prison for long.
There's a way to avoid all of this,
This is what I feel.
not to commit a crime.
It's true.
That's what we're here on. But it's a similar crime that you were convicted of before. Aggravated assault. I mean, that's the problem is you're supposed to learn, we got to stay away from this like it's the bubonic plague.
It's true.
It has its consequences. And then this offense was committed in real inhumane fashion with the gun being, that was just an anger act. I mean, that's meanness. It's not the way you're supposed to treat anyone, much less a close relative. Right?
It's true.
Someone you're supposed to love. What would you do to someone you didn't like? We had 9 prior misdemeanor convictions and 3 prior felony convictions. 2 of those felonies, violent crimes, arson and aggravated assault. And then terroristic threat, harassment, assault, family violence, terroristic threat, assault, family violence. It's 1, 2, 3, 4, 5, 6, 7 other acts of violence. You don't think it's time that you stop committing acts of violence? Anything else? If nothing else, I find as follows that the defendant has pleaded guilty, has been found guilty beyond a reasonable doubt of this aggravated assault, family violence as alleged in this indictment. Thereafter, being found guilty by a jury verdict, the defendant entered pleas of true voluntarily, knowingly, intelligently to the allegations of prior convictions in paragraphs 2 and 3 of the indictment, where it's alleged the defendant was finally convicted of arson on February 1st, 2001 in the 252nd District Court of Jefferson County, Texas. Thereafter, that became final. The defendant committed the felony of aggravated assault and was finally convicted of that felony in 2010 in this court. And then subsequent to that, he is charged and convicted with the March 17th, 2022 aggravated assault, family violence. So the court finds that there is sufficient evidence supporting the finding of guilt beyond a reasonable doubt, and paragraphs 2 and 3 are proven true beyond a reasonable doubt, which puts the defendant in habitual offender category of sentencing. So he's looking at no less than 25, nor more than life, up to life, 99 years or life imprisonment. That's the punishment range the defendant is looking at. If nothing further to add by anyone, the defendant has been found guilty of this offense, is subject to this punishment range of habitual offender status. The defendant is hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 35 years. And the judgment shall reflect that an affirmative finding shall be made that a deadly weapon, namely a handgun, was used in the commission of the offense. You understand what has happened today, sir? Anything else?
No,
That is all.
thank you.
Here's this. Thank you.